On behalf of SLED and the South Carolina Criminal Justice Academy, I'm here today to provide some guidance on South Carolina's upcoming implementation of the Open Carry with Training Act, and specifically how this law impacts law enforcement interactions with citizens who choose to openly carry a handgun in South Carolina. The Open Carry with Training Act has a delayed implementation and does not go into full effect until August 15th, 2021. However, on or after August 15th, 2021, individuals who have a valid South Carolina concealed weapons permit and individuals who are valid permit holders from states that South Carolina gives CWP reciprocity to can openly carry a handgun in South Carolina, so long as they abide by the South Carolina law on where permit holders can legally carry. That is a lengthy topic for another training session, because I want to focus today on law enforcement interactions with citizens who are openly carrying. The law in South Carolina is clear. A citizen must have a valid permit in their possession to carry a handgun in public in South Carolina. This applies whether the individual is carrying concealed or carrying openly. However, the circumstance under which a law enforcement officer can detain an individual solely to check for a permit requires some analysis. Let's begin by discussing consensual law enforcement encounters with the public without any reasonable suspicion. Obviously, law enforcement officers can approach anyone in the public to ask general questions of that individual, even absent some reasonable, articulable suspicion of criminal conduct. You can also offer help or assistance to any member of the public. However, because this is a consensual encounter, the individual does not have to respond to you, does not have to answer your questions, and can simply ignore you completely. Worse, this individual can be rude and obnoxious to you and can tell you off with vulgarity. The state and federal constitutions guarantee individuals the right to do this. So, while you can ask about a permit, you simply cannot detain a person or temporarily restrict a person's freedom, even slightly, without reasonable suspicion of criminal conduct. And, after August 15, 2021, a person openly carrying a weapon, absent any other indication of criminal conduct, is not enough. Think of this in terms of a vehicle stop. Can you pull a vehicle over simply to check if a driver is properly licensed without reasonable suspicion of criminal conduct? No, you cannot. Even though it is a crime to drive without a license, you still must have reasonable suspicion of criminal conduct to make a traffic stop. The consensual law enforcement encounter presents the same situation. Now, if you do have a reasonable, articulable, and particularized suspicion that an individual is engaged in criminal activity, you can investigatively detain the person for a brief period of time, and you can ask them questions to confirm or dispel your suspicions. In this instance, while a detainee is not generally required to respond, South Carolina law requires a permit holder to inform a law enforcement officer that they have a permit, and the law requires that the permit holder present it to a law enforcement officer upon request. In this instance, because you have a reasonable suspicion for the detention, you can demand production of the permit if the individual doesn't present it to you. If the person is carrying a handgun, whether open or concealed, without a valid permit, the person is in violation of South Carolina law, and you have the discretion to effectuate a custodial arrest. Let's walk through some scenarios to highlight these points.
How you doing, sir? I'm Officer Throw. I see you're openly carrying your firearm. Do you have a CWP on you? All right, have a nice day.
In this scenario, you have no reasonable suspicion of any criminal conduct. You just see someone open carrying and you approach them to talk. They ignore you completely and act as if you were not even there. You cannot detain this individual, even briefly, to check for a permit.
Hey, how's it going, sir? I'm Officer Lubinsky. I see that you're open carrying there. Do you have a CWP with you?
No.
Did you realize in South Carolina you need to have a CWP to open carry?
No, I did not.
Okay. I need you to turn around, put your hands behind your back. We're going to be detained. You're not under arrest at this point. We're going to work this out, okay? You don't mind turning around right now?
In this scenario, you have no reasonable suspicion of any criminal conduct. You just see someone open carrying and you approach them to talk. You ask if the person is a CWP holder and they say no. They weren't required to even answer, but they did. Now they have admitted to breaking the law and you have probable cause to arrest. At the very least, you could certainly briefly detain the individual and demand production of the CWP as part of your investigative detention.
What is your emergency?
I just saw this guy break into a car. He's a white guy wearing a blue shirt and a black baseball hat.
Excuse me, sir. You mind stepping over here for a second?
Yes,
I'm Officer Collier. What brings you out here today?
I'm just walking to a friend's.
Alrighty. Where are you coming from?
Down the road.
Okay. I noticed you got this radio in your hand with some cut wires. Where'd you get your radio?
I just found it in a stream.
Alrighty. What's your name?
Jake.
Jake. What's your date of birth?
November 7th.
Okay. I noticed you have a gun on your side. Do you have a concealed weapons permit?
Not on me.
Do you have one?
No.
In this scenario, you have a caller indicating that a white male in a blue shirt and black ball cap just broke into a car. You see an individual matching this description walking down the road near the location of the reported break-in carrying a car stereo. You approach the individual and see that he is openly carrying a handgun. You identify yourself as a law enforcement officer and ask the individual who they are, what they are doing, and whether they have a valid permit to be carrying. They are nervous, vague, evasive, and give answers that just don't add up. Can you demand to see the individual's CWP at this time? Likely yes. Based on the totality of the circumstances presented, you should be able to articulate reasonable and particularized suspicion that this individual is engaged in criminal activity. In this scenario, once you have identified yourself as a law enforcement officer, you can demand the identification and the individual must produce it. This one was a pretty straightforward scenario, so I also want to give you a brief refresher on reasonable suspicion. It is not enough that a person is in a high crime area or that there have been recent break-ins or criminal activity in the area. You must have a specific and individualized suspicion of criminal activity to detain an individual. And after August 15, 2021, simply open carrying a handgun, standing alone, is simply not enough to justify even a detention of any kind. Additionally, after August 15th, you may see Second Amendment auditors showing up in your jurisdiction in an attempt to challenge you into a non-consensual law enforcement encounter. First and Second Amendment auditors usually try to bait law enforcement officers into a confrontation, which ultimately results in an unlawful detention or a confrontation that can be posted online to garner attention. They will generally open carrying in a well-traveled public area or in front of a government building in hopes of being spotted by law enforcement or a member of the public who then calls law enforcement.